Welcome to the bold analysis, ladies and gentlemen. It has been long since I did a video standing, but the podcast I want to do here is very critical. Today I've been busy in the field. I'm still in Nyandarua. So I did not follow the proceedings to the letter. But one video from Rigathi Gachagwa's lawyer is what has really touched me, and I want us to base our arguments on that video. But let me start here. When the Supreme Court in 2017 nullified the results that declared Uhuru Kenyatta the winner, I remember something that Justice David Maraga said, that it is not just about the outcome, the results. It's not just about the number, but the process on how you arrived at the numbers. And let me just remind you a bit. Some of Forms 34A in that 2017 general election had fake signatures and security marks in them, security features in them. And that was one of the grounds in which that election was nullified. Let me bring you to BBI. When the same Supreme Court stopped the BBI, they said that the president cannot initiate a referendum through the popular initiative. The popular initiative is not at the disposal of the president. But the president's only proposal is through the parliamentary way. And so, an impeachment still also should not be initiated by the president because of the privileges of power. Ladies and gentlemen, Rigathi Gachagwa's lawyer, Ongoya, was exposing William Ruto's memoranda to the courts, and a clear sign of William Ruto's vicious hand in Rigathi Gachagwa impeachment in the spirit of those past two Supreme Court judgments. Rigathi Gachagwa impeachment should be suspended on just that one basis, that President Ruto's hand is in it. And I want to explain for you why that is a red flag. Before that, I need to give you an update, and I want to say thank you. Today, on 29th, today is Wednesday, Tuesday, we have done 2 houses. So this is the first house we did. By the time I was doing this video, it was late in the evening. We had done the wall, the mabati. In fact, the fundi was just working on the windows and the door. And so tomorrow, they are going to finish the floor, and this house is 90% done. What is remaining is actually the floor. So this is house number 9. I remember I was telling you there are 3 houses that we were doing granny care, supporting, building these 3 houses for our elderly senior members of this society here. Then the second house I want us to look for, that one belongs to Mzee. I've forgotten the name. Is it Mangi Maina? I think I'm not wrong. Then there is this other house by Penina Nyambura. So Penina Nyambura's house is also done. Just the doors had just arrived, but the fundis had gone into the late. So the fundis had not just put the door, and they're supposed to put the window and finishing for the floor tomorrow. For these 2 houses, they're 90% done.
Hello guys.
Mungu amubariki sana.
Umefurahi?
Nafurahi sana.
Tunashukuru Mungu sana.
Mungu asaidie mimi. Nishishi. Amusaidie kabisa.
Tuliambiwa nyumba uende utalala peke yako. Uende utalala huko sasa.
Haya, italala tu mzuri.
Yeah, so guys, this is the second house. We've already done the back and the structure. The fundis were... Yes, so Shosha is interrupting because she's saying thank you.
Bariki kwa Kikuyu?
Muradimo muno.
Muradimo muno.
Muno.
Saidi.
Namokea matukonegai.
Uongezo miaka na Mungu.
Anatuongeza miaka na Mungu. Asante sana.
Nafanya kazi nzuri.
Asante sana. Na Mungu aye pia Mungu akuongezee pia hizi miaka zisonge.
Ndio.
And I want to say thank you. Oh, this has been so tedious because remember you have to move to be the ground. But I like working. I really love working in the community. It's really fun working in the community. So there's 2 houses we've done. I think the floors is what will be done tomorrow. So the 3rd house we started late in the evening, and it is what I want us to look at here. It is what has now been pending. Tumesha chimba, tukaeka hizo logs. So tomorrow, the pending part is the mabati and the windows and the floor, which I believe should be done tomorrow. Now I happened to have a short interview with Shush Alice, the daughter is also there, and I want us to get a snippet of that.
Ni tukenete muno uyu ni mami mujiari na ni tukenete ni guturehera andu aya nyumba ni kinyete hau ikinyete itigeti mabati na ni turakena muno tukimwihoera tugacokia ngatho muno na Ngai itu murathime muno na muongere mbarikiwe sana. Tuko na furaha.
Ashikanishi mkubwa sana.
Darani kama undu wega nikyo ajira ndugame haha njokie ngatho ciake twina gikeno kiingi muno twina brother haha na aya murehete guku Ngai amurathime ni tuna muguthi na mbere na guturekereria murathimo ni Ngai muno na mutikanage mbarikiwe sana atore mwendete kukuka mbarikiwe sana ampenda Mungu ambariki sana.
So thank you very much. So this is the one that we are now having a deficit. I believe if we can fill the gap, I think we'll be able to finish this project tomorrow. Nyumba imebaki ni nyumba ya 3. The other 2 houses we are done. The floor, kesho wataweka 2 floor na dirisha na mlango watakumaliza, so wao hata kesho wanaweza ingia. Then the only one that is now remaining is this one for Mama Alice, which we supposed to then continue tomorrow. Remember huku tujeka hata mabati, tujeka hata floor, tujeka hata dirisha, but we believe and we trust God that, and we pray that it will come also to a success. So kindly let's marshal up. This is the last mile. I think the next video I should be doing tomorrow, I should be done. So thank you very much, and for really those who are supporting this, asanteni sana. I've really felt of these projects, I've really felt this one. Guys, take a minute and listen to Ongoya.
And let's face it. The process of 18th October 2024 took 6 hours as a deliberate scheme to defeat each of the principles and values of good governance I have alluded to: transparency, accountability, procedural fairness, and public participation. Who did these violations? We are also here to call people to account. Who did it? Between the time we left Senate around midnight, between the time Senate closed business around midnight of 17th October 2024, and the time we woke up to the presidential communique of 18th October 2024, in that night, the Bishop Oginde-led Ethics and Anti-Corruption Commission is documented in the President's memorandum to have received, processed, and given a clearance to Honorable Kithure Kindiki. That night. My lords, history is important, and I may not remind you why our constitution prescribes that our presidents be sworn in during the day. We were all adults, we know where that comes from. It's one of the most autochthonous provisions of our constitution. And therefore, when things happen in the night, we have reason to have our antennas high. Between the time Senate rose on the night of 17th October 2024 And the time we woke up in the morning of 18th October 2024 to the President's communication to the National Assembly, we were told that the IEBC, which we now know is not properly constituted, has no commissioners, had purportedly cleared Honorable Kithure Kindiki in the night. I will not say much about KRA because I think KRA can work overnight and we will not complain. But it was that memorandum. The other culprit was the president himself. The president of the Republic of Kenya undertook these clearances overnight and in the morning had a clear proofread memorandum. Exceptional efficiency, we celebrate that. To Parliament. Then the National Assembly itself. Now this is curious. The National Assembly itself had called a sitting prior to the resolution of the Senate. The sitting was called prior to the resolution of the Senate. To sit on a day, ordinarily not a day of sitting of the National Assembly, to process a resolution of Senate it had anticipated, the removal of a deputy president from office and processing clearance or approval of another deputy president. We sit here as judges, we sit here as court assistants, we sit here as advocates representing various parties. I don't know who among us, once we take away the cloaks of the official roles we play, was proud as a Kenyan observing these events as they happened. I don't know who among us was proud now putting on the cloak of citizenship to watch these events unfold at that pace. Fortunately for us, my lords, my ladies, we have a judiciary of Honorable Richard Mwongo that arrested this process in its tracks to give the Constitution a chance to roar. In the far corners of Kerogoya. Fortunately for us, we have the judiciary of Honorable Chacha Mwita, His Lordship, that arrested this process to give the Constitution a chance. Today, you sit and I stand before the judiciary of Honorable Ike Ogola, Honorable Esim Rima, and Honorable Dr. Frida Mugambi, that has been invited by the respondents to undo that chance that the Honorable Mwita and the Honorable Mwongo gave the Constitution. We don't begrudge them for that invitation. Because under Article 48, they are entitled to come here and make that invitation. Our question is whether the judiciary of Honorable Gola, Honorable Mrima, and Honorable Dr. Frida Mugambi will be baited by that invitation. That's our only question. Throughout these proceedings, we shall be looking at you in the eye to ask, will you fall for this bait or will you stand for the Constitution? Having laid out our broad attitudinal view of this matter, allow me to address you now on the law and the jurisprudence of conservatory orders. In terms of textual prescription, in terms of the prescription of text of the Constitution, we will find accommodation for conservatory orders in two aspects of Article 23, Clause 3 of the Constitution. Article 23, Clause 3 says, in any proceedings brought under Article 22, a court may grant appropriate relief. So we find accommodation of conservatory orders in the use of the phrase appropriate relief, because appropriate relief is wide enough to accommodate anything under the sun that is necessary to give effect to a right, fundamental freedom, or I dare say, any other provision of the Constitution. The second accommodation is in paragraph C of Clause 3 of Article 23, which says, in any proceedings brought under Article 22, a court may grant appropriate relief, including, say, a conservatory order, expressly. I'm a bearer of good news that in determining whether or not to grant conservatory, to confirm these conservatory orders, my lords, you need not look further than in the files before you. I'll demonstrate you shortly. Just by looking.
This video by Elisha Ongoya. And what Rigathi Gachagwa's legal counsel has successfully maintained, I know the country is looking at it as a wrong step or not really hitting the nail in the head. One thing that Rigathi Gachagwa's lawyers realized is the die is cast. The decision has been made. What they're successfully doing is to build a case for the Supreme Court. They've successfully, and this I can say with a very strong conviction, Rigathi's lawyers have successfully explained to the country the viciousness of William Ruto and the way things were done against the law in some very unfamiliar situation. For example, what Ongoya is talking about is how we ended up having the name Kindiki, just, the clearance done at night. IBC called, NIS, DCA, all called at night to clear Kindiki. And as if that might not sink, how, if you want to see the process is predetermined, a day before even the Senate proceedings, Parliament had already called a special sitting to vet the new deputy president. And I said successfully, I think, you're convinced, if you look at the way the impeachment all the way to Kindiki clearance has been handled, the president's hand is not hidden in this impeachment. And I want to explain to you why, even if other factors might not hold, but this is a danger that the court must, or rather should, pronounce itself. In 2017, Maraga said, it's not about the results. It is about the process. It is also about time for the Supreme Court to ask and interrogate the process. It is not about producing an outcome of impeaching the deputy president, but it should also be about the process. And if I pick the BBA one, the president, William Ruto and Raila Odinga, were told that Uhuru Kenyatta, not William Ruto, Uhuru Kenyatta and Raila Odinga, that Uhuru Kenyatta cannot initiate a referendum to do the popular initiative. That can only start in the National Assembly. And even despite the fact that even despite the fact that Waweru and Junet Mohammed, Waweru and Junet Mohammed was in parliament, and that document went through parliament. The president was told Uhuru Kenyatta that there's no problem with BBI, the BBI is fine, but it cannot start with you. There is no problem with impeaching the deputy president. Impeachment is domiciled in the constitution, but we should not allow the president to be the initiator of that impeachment. We should create that immunity. And I want to tell you why that is a red flag. The country and the Supreme Court must interrogate and give Kenyans an answer. The Constitution was suspended to facilitate Rigathi Gachagua impeachment. In the Senate, Rigathi fell ill, was evacuated from the Senate chambers. They had an option of pushing the sitting to Saturday. They moved through, and Rigathi was voted out unheard. While they had a way, they could still give time. There was no urgency. There was some created crisis. Even up to date, we still don't have a deputy president. We still have Rigathi as the deputy president, still not installed that Kindiki. So the courts must actually ensure that never again shall a constitution be suspended to facilitate an impeachment, or even not an impeachment, but an illegality, and to facilitate a president's wish. The President of the Republic of Kenya is one person. I think the Constitution of 2010, probably William Ruto never supported, yes. It gave us some impetus, it gave us some leeway. It is the only hope the country have. And we insist, and I think this should sink, that the Constitution should not be suspended for political expediency. Today, it is Rigathi. Tomorrow, it will be a Supreme Court judge. The other day, it will be a cabinet minister. The day after that, it will be the Speaker of the Senate. I remember, there's a national assembly. I remember recently, there was a story here that there is an impeachment motion against Wetangula, so that that post can be given to someone from ODM. You know, we must ensure impeachment is political, but it is not a political tool to change Onyango with Otieno, to change Kamau with Wanjohi. Impeachment was a tool to remove So, because So is not fit for the office. But it was not at the time when I feel I want So. I don't have a good relationship with So I need to chase So that I bring So. No. Even if Rigathi wanted, if Ruto had an agreement with Kindiki that after 2 years he will be the deputy president, so they should just give it to Rigathi, they must get something else. Because look at the economy of our politics. Kenyan government, Kenya spends billions to go to an election to elect a president and a deputy. Then after that, you come out in one night, in 2 days, then you overturn that. No. Secondly, the Supreme Court must be able to tell the executive and the two arms, but the executive and the legislature, the institutions that were built like IBC, DCI, NIS, you can name them, should not work at the behest of the president, or they are not properties of the state, they are properties of the people. How? You want to convince me? IBC is not fully constituted. It is the one that is supposed to clear Kindiki. It cleared Kindiki at night. But this IBC, because the president needed it, they had to make that clearance at night. However, there are constituencies and wards in this country that don't have a representation in parliament because IBC is not fully constituted and by-elections are supposed to be done there. So by-elections cannot be done because IBC is not fully constituted, and the president and the team are adamant on constituting IBC. Our constitution also put it clear. After 10 years, our boundaries should be demarcated. Our boundaries should be reviewed. The boundaries review is supposed to yield some constituencies, fold others, and that will make part of the policy formation for revenue allocation, both for counties, constituencies, and wards. Now, counties like my county in Sia, let me just talk about my constituency, Lego Songa, that is supposed to be prime for split, cannot be split so that they enjoy more resources simply because someone is sitting on a decision to constitute IBC. So that should be it. The institutions must work for the people, not for the leader. The president's hand in Rigathi impeachment is a red alert because if we allow the president to have the leeway to initiate removal of his deputy, you know what we are doing? We are setting a precursor. We are setting a precedence for abuse of that privilege. I want to ask you, just tell me, you are an MP sitting in parliament. You already know there are reports that the president even called some MPs, some people, and you're receiving a call from the president that I want you to remove so and so. You're getting that call, you're a speaker, and the president telling you have to do this. Tell me, even if Rigathi is to bring all manner of lawyers in the Senate and the National Assembly, will you listen to that? Will you listen? No. Because you don't know, you know when president calls you and tells you, I want you to do this, most likely people will do it. Why? Because probably you have a file lying somewhere about some corruption that can be pulled against you. You have some case, decade-long case somewhere about land that can be pulled against you. You have some tender, I don't know this, that can be pulled. So you are under-intimidated. And I say, the court must insulate this so that it is not just for the Deputy President Rigathi Gachagua, but it is for the country Kenya. It might not be Ruto today. Tomorrow there might be another president who will also feel like, I want to chase this minister, but I don't want to do a reshuffle. I must make sure that this minister does not rise above being this minister. So I must make sure that minister is impeached. Look, impeachment is not a joke. If you're impeached, you cannot vie. So this is someone hitting a nail on your political career. And that is why I believe it should not be left on the president. The president should not be involved in it in whatever way. Because, in fact, let me tell you, the process can only be clean. The process can only have fairness and bias if there is no coercion from behind. When we allow the president the privilege of pushing it, it is danger. Number 4. Rigathi and Ruto impeachment is a political disagreement between two gentlemen. We've been told stories about how, I don't know, they are in Kisumu, and Rigathi was saying that some agents were working with Rat looking for how they can pour in his food. Someone have said the way, I don't know, we were in cabinet, we agreed, you went out, you said something else. You know, someone have said there is insubordination, the president talk about unity, you're talking about shareholding. So the whole thing is Ruto begrudged his deputy. And that is why I'm saying It is a disagreement. But the courts must not be invited. When MPs were in current residence, voting on who to become the deputy president in Kenya Kwanza agreement, there was no judge there. There was no judge. So the courts must tell them to go back and fix their politics so that they can save the country. All this. We want to talk about Adani. Let them go and lock themselves in a room and fix their mess. And I think, looking at this, the courts must create a Berlin Wall. And this Berlin Wall is to shield themselves from political infiltration. There is a clear, now it is very clear, a clear denominator in this regard impeachment is Parliament was infiltrated. The National Assembly was infiltrated. The Senate was infiltrated. State institutions were infiltrated. And that's what the legal lawyers have successfully told the country. Now, if the court also, Justice Mongo and Mwita gave the court, the law, its space. If the court also fall to that trap, they shall have just completed that chain. Which to my end, I think they can do better. I strongly believe, just on the fact that William Ruto's hands are in this impeachment, that should be a ground for the courts to say no. Remember, they swore affidavit, and remember, the president's lawyers walked out. Why were they all walking out? They're walking out so that they can disown the memoranda from the president. But Ongoya was out, went there with it. And I think the courts must agree, should also look at this. The casualty is not only Rigathi Gachagua. The casualty is not only Rigathi Gachagua. The casualty are even workers in his office. Do you know, someone who was working in the office of the deputy president as a chief of staff and as an advisor, as a security, as what, all those. Apparently all of them are being sent on leave because of the deputy president Rigathi Gachagua. So look at that. And the courts have told them to bring their contracts. They could be reinstated. But to look at the political, the political dirt in it, we must, and I think the court should not sanitize it. And that's why I strongly believe that let the court suspend that impeachment. Then on those criminal charges, let us see files being investigated by the DCI and the DPP. When we have a case on the criminal charges against the president, I think they still have a leeway of starting another impeachment. Martin Wambora faced several impeachments. The same way governors have been facing several impeachments. And I know very well that if there will be a second impeachment against the deputy president, even if he survives this, there will be another one. It is not simplistic as what the country is being treated to believe. Thank you. And kindly let's support Nyandarua mission. Asante.